is not limited to investment. This concerns unlawful restriction.
Some problem with the net or something like that?
Lordship, I think it is some connectivity issue. Can we wait for 2 minutes?
Yeah, no problem.
The other member from the team, please check with the. Yes, she is back.
She is back.
My sincerest apologies. May the council continue?
Yes.
Much obliged. Your Excellencies, however, we submit that the claims that Island of Tina is submitting is not limited to investment. It concerns unlawful restriction of rights, unlawful expulsion, arrest, and detention of an alien, and uncompensated expropriation of foreign property, which falls under the compulsory jurisdiction of this court. Your Excellencies, we now move to the arguments. Firstly, I shall submit that Tina has standing over the claims following its legal interest in protecting the rights of Mr. Cristianiniho under diplomatic protection principle and the enforcement of obligation erga omnes partes. Your Excellencies, firstly, Mr. Cristianiniho is a national of the island of Tina. The ability of a state to exercise diplomatic protection on behalf of a national is imbibed in customary international law. As such, Your Excellencies, Tina's claims on behalf of Mr. Cristianiniho are maintainable before this court. Secondly, Your Excellencies, Profin is a transnational company that was established in the neighboring island of Tina. You can see this in the factual matrix at paragraph H. Your Excellencies, we submit that under general circumstances, Tina cannot submit claims on behalf of Profin since it is not the state of nationality of Profin. However, Your Excellencies, this court, in the case of Barcelona Traction, foresaw the development of foreign direct investment and imagined certain exceptions where a state, despite not being the state of nationality of corporation, can submit claims on its behalf. Your Excellencies, one of these exceptions was that when a state itself is an investor in a company. Your Excellencies, this is on account of the fact that such an investment makes a part of the national economic resources of a nation. Your Excellencies, this is relevant to our case since the island of Tina has a sizable investment in the company of Profin. Therefore, we submit that although Tina is not the state of nationality of the corporation of Profin, it can submit claims on behalf of Profin. As such, the claims of Tina on behalf of Profin are maintainable. Your Excellencies, we now move to the claims that have been submitted by the island of Tina with respect to the women of Chester. Your Excellencies, states party to a treaty owe the fulfillment of the obligations under the treaty to all the parties of the treaty. This is the principle of obligation erga omnes partes, and this court propounded this principle for the first time in the case of Belgium versus Senegal. Your Excellencies, as we can see in paragraph T of the factual matrix, the Republic of Chester and the island of Tina are both parties to the ICCPR. As such, Tina can invoke obligation erga omnes partes with respect to the unjust limitations on the reproductive rights of women and the undermining of the agency of women to give informed consent under the ICCPR by the Republic of Chester. Additionally, Your Excellencies, Tina has a special interest in the claim, insofar that it has suffered injuries at the hand of Chester. The unlawful restriction of the rights of women has now led to the creation of a refugee crisis in the region of Shambhala under the control of the Republic of the island of Tina. This can be seen in paragraph S of the factual matrix. As such, Your Excellencies, since Tina has a special interest in the claims, and it can invoke obligation erga omnes parties of Chester as party to the ICCPR, Tina has standing to submit claims on behalf of the women of Chester.
I have a question for you. Since Chester is in the clutches of a public emergency, is it not permissible for it to derogate from its ICCPR obligations?
Much obliged, Your Excellencies. Your Excellencies, for a state to derogate the rights of its citizens under Article 4 of the ICCPR, there is a procedural obligation that it must follow, which includes a communication that must be provided to the international community via the Secretary General. However, Your Excellencies, Chester has not obliged with this particular provision of the ICCPR. It has made no such communications to the international community regarding the measures it has taken regarding the public emergency that is pertaining in the Republic of Chester. As such, Your Excellencies, yes, Your Excellency.
So what is your stance on Chester's substantive right to derogate, irrespective of shortcomings with regard to formalities?
Much obliged, Your Excellencies. Your Excellency, in the case of Huaman versus Peru, the Human Rights Committee specifically determined that the substantive right is dependent on the procedural right of a state to inform the international communities of any derogations from the obligations under the ICCPR. As such, Your Excellencies, in the very case, the Human Rights Committee dismissed the claims that had been made by the state, and it adjudicated that all the claimants in this particular case be returned their rights to political activities. As such, Your Excellencies, on these grounds, we submit that the procedural obligations under Article 4 are equally as important as the substantive right of a sovereign to derogate. Your Excellencies, we now move to the exhaustion of local remedies rule. Your Excellencies, we submit that it is a well-established rule that methods of dispute resolution must be sought before submitting an international claim. This particularly includes the exhaustion of local remedies when diplomatic protection on behalf of natural or legal persons is invoked. However, Your Excellencies, given the circumstances of this case, we submit that exceptions to the local remedies rule apply. Firstly, Your Excellencies, Mr. Cristianiniho was secretly arrested and detained by Chester, which manifestly precludes him from exhausting any local remedies. This is a principle which was recognized by this court in the case of Lowen Group. Your Excellencies, since there is no reasonable possibility of effective redress, as there is a consistent and well-established line of precedents adverse to the aliens, which in this case are Mr. Cristianiniho and Prof, we also submit that exhaustion of local remedies is not applicable. We submit that this adverse line of precedents is on account of, firstly, the secret arrest and detention of Mr. Cristianiniho and the issuing of compulsory license against the will of Profin and the island of Tina. Finally, Your Excellencies, in accordance with this court's decision in La Grande, we also submit that if local remedies were available for Mr. Cristianiniho and the company of Profin in the Republic of Chester, it had a duty to inform them of such local remedies. However, it failed to do so. As such, there is no necessity for Profin or Mr. Cristianiniho to exhaust local remedies. Additionally, Your Excellencies, in an attempt to settle the dispute between Chester and Tina, both parties have engaged in negotiations and other peaceful means. This has been provided by the factual matrix at paragraph S. However, we fail to reach a common ground. As such, Your Excellencies, on these grounds, we submit that the claims by Tina made on behalf of Mr. Cristianiniho, Profin, and the women of Chester are maintainable before this court.
Madam
Your
Counsel, I have a question for you. That did the gentleman who was arrested, did he take any local advice or did he consult a local council in the jurisdiction of Chester before moving this?
Much obliged, Your Excellencies. Your Excellency, at the time of speaking, Mr. Cristianiniho is still in detention. As soon as he was expelled from the territory of the Republic of Chester, he was secretly arrested and detained. As such, Your Excellencies, Mr. Cristianiniho is in no position to seek any legal advice from anyone.
All right.
Much obliged, Your Excellencies. We now move to the second leg of the argument, which is that Chester's unlawful restriction of reproductive rights and national laws that undermine informed consent of women are not within the scope of its sovereignty. Your Excellencies, we would like to reiterate that the winter starve pills consumed by women, which have been proven to prolong their lives by 10 years at minimum and improve their immunity levels, have suddenly shown side effects, which include the disruption of menstrual cycles, neonatal deaths, and stillbirths. Consequently, the sex ratio of the Republic of Chester has also been affected. Your Excellencies, the Council has already clarified how derogation in this particular instance is not permissible. Also, Your Excellencies, we would like to clarify that the restrictions that the Republic of Chester has placed is in accordance with the rights protected by Article 17, paragraph 1 of the ICCPR, which protects against arbitrary or unlawful interference with family, privacy, and home. Your Excellencies, the Human Rights Committee has interpreted that this particular right also includes the prospect of contraception and abortion. Your Excellencies, in an emergency condition, a sovereign state can also limit such rights. However, Your Excellencies, this limitation should be provided by the ICCPR itself. Your Excellencies, with regards to Article 17, paragraph 1, we do not see any such permissible limitations in the covenant itself. As such, Your Excellencies, even limitation by the Republic of Chester cannot be pleaded. Your Excellencies, in addition to the unlawful restriction of the rights of women, we submit that the national laws of Chester have also undermined the agency of women to give informed consent. Your Excellencies, Article 7 of the ICCPR provides that no one can be subjected to medical experimentation without their free consent. The equal enjoyment of this right is ensured by Article 3 of the Covenant by both men and women. Your Excellencies, returning to the facts of this case, Chester was closely informed by the proceedings of the research, and the local government of Nick was even involved in the process of research. However, Your Excellencies, in the first phase, a lot of women were entered into trial run agreements without their informed consent and on the basis of the permission of the men in their family. Your Excellencies, I see that my time is over. May I conclude my arguments?
Yes.
Yes, you may.
Conclude. Conclude.
Much obliged, Your Excellencies. Your Excellencies, we would finally like to stress in the fact that these trial run agreements had to be enforceable under national law. And as such, the fact that women were able to enter into these agreements without their informed consent speaks to the discriminatory laws that the Republic of Chester has. Your Excellencies, the learned counsels of the respondent in paragraph 22 of their arguments at page 10 advance that the incapacity of women on grounds of unsoundness of mind and the condition of unconsciousness resulting in death without medical treatment must be considered on account of the lack of informed consent. However, Your Excellencies, we submit that no such factual matters exist at hand. And to make such a leap with regards to the agency of women to give informed consent cannot be justified by invoking state sovereignty, which has been invoked in arguments 2.1 and 2.2. Your Excellencies, finally, we submit on account of the lawful restrictions on the right of women and discriminatory national laws, it is established that Chester has exhibited a pattern of persecutory treatments towards women. The limitation of rights contravene Articles 4 concerning derogation, Article 5 concerning limitation, Article 17, paragraph 1 concerning the right against arbitrary interference in family, and the discriminatory laws of Chester, which contravene Article 3, the equal enjoyment of rights by men and women, and Article 7, which provides that medical experimentation must be with the free consent of research subjects. Your Excellencies, if you have no further questions, my co-agent will now be dealing with the third issue.
Yes, thank you.
Your Excellencies, may it please the court. I'm here for the applicant, Island of Tina, and I shall submit on the third claim of unlawful expulsion of Mr. Cristianino. The unlawful and arbitrary arrest and detention of Mr. Cristianino without the access to the consular notification And finally, the expropriation of the property of Prof without compensation by the government of Chester, which are in the violation of Chester international obligations or obligations under international law. Your Excellencies, may I proceed with the first submission of the issue? Your Excellencies, Mr. Cristianino, a national of TINA, who had been residing in Chester for the last 18 years, was expelled from the Republic of Chester by the expulsion order number 512, dated 19 November 2021 by the Ministry of Internal Protection and Security. Before Mr. Cristianino could leave the country, he was again detained by the Chester's authorities. This act of Republic of Chester in violation of Article 13 of the ICCPR, to which both the state before this court are parties to. We agree that state has an inherent right to expel nationals within its territory, but the right to expulsion defined in Article 13 of ICCPR is not an absolute, but it is conditional. The conditions are: first, such expulsion must be carried out with a decision in accordance with law, and secondly, the expelled individual has to be allowed to submit the reasons against the expulsion and have his case reviewed before the competent authority. In our case, the Republic of Chester exercised the right of expulsion, but without giving the due considerations to the conditions applied. Firstly, the expulsion by the Ministry of Internal Protection and Security has no legal basis or grounding in domestic law of the Chester, and Chester has failed to provide the provisions of the applicable law, both substantive as well as the procedures as established in its domestic law, while reaching the expulsion order. Thus, the expulsion is arbitrary. Secondly, Mr. Cristianino was deprived of his right to defend himself before a competent authority against the expulsion. Further, the only exception to this, as given in the Article 13 of ICCPR, is the compelling national security reasons, and it is not present, as the right can be exercised only for the protection of the existence of the nation, its territorial integrity, and the political independence against the force, which has been confirmed in the paragraph 19 of the Siracusa Principles of Limitation and Derogations of the Covenant of ICCPR.
Yeah. So cannot one say and any compelling national security and health reasons to detain Mr. Cristianino?
Yes, Your Excellency. Could you please rephrase the questions,
Yes.
Your Excellency?
Are there compelling national security and health reasons for the expulsion of Mr. Cristianino?
Your Excellency, however, the only reasons that the Republic of Chester itself has cited for the reasons of the expulsion of Mr. Cristianino is making the reckless profiteering and causing the health crisis in the Republic of Chester, which do not meet the compelling reasons of the national security that meets the territorial integrity and the political independence of the Republic of Chester against the force. Therefore, the expulsion was not for the compelling reasons of national security.
For health reasons, can it be done?
No, Your Excellency. If for the health reasons, it has the public health limitations of the right, but according to the Article 13 of ICCPR, it clearly states that it should be for the compelling reasons of the national security. Thank you, Your Excellency. However, further, the accusations of creating health crisis is also baseless without concrete evidences, because he, as the shareholder of the Prof, cannot be held responsible for the side effects of the research of the Prof, which has its separate legal personality. And both these conditions can be seen in the Sario Diallo case in the judgment of 2010 by this Honorable Court, as it has confirmed that the requirement of the condition of conformity with the law, as well as the requirement of the state to demonstrate there existed the compelling reasons of national security when there is the deprivation of the right to proceeding before the competent authority. With regards to the unlawful detention, thus, the Republic of Chester has failed this obligation and violated the Article 13 of ICCPR. Likewise, Mr. Cristianino was also arrested secretly and kept in the detentions with regards to the unlawful, and the Article 9 of ICCPR protects individuals from the arbitrary arrest or detention ensuing the deprivation of the liberty, and deprivation of liberty is carried out on the grounds and procedures as established by the law, and such arrested persons should be informed of the charges promptly as well as the reasons of his arrest and brought promptly before the competent authority. The Article 14 of ICCPR also affirms these rights. However, it is clearly stated in the facts of the case in the paragraph Q of the compromise, Mr. Cristianino was arrested secretly and kept in the custody without the legal recourse, making the arrest and the detention arbitrary against the Article 9 of ICCPR. Firstly, the arrest and detention was without legal basis and procedures established by the law. Such arrest and detention without legal authorization and clear domestic legislation is unlawful and arbitrary, which is confirmed by the Human Rights Committee in McLaren's versus Jamaica case in its 5.5 paragraph. Likewise, secondly, Mr. Cristianino was not informed of the reasons of his arrest as well as the charges, whether the arrest and the detention was for the legitimate or the improper reason. Mr. Cristianino was not informed on whether he was arrested for the purpose of the expulsion or for the criminal proceedings. Also, the deprivation of the fair and impartial trial before the competent authority or the court is also proves that Mr. Cristianino was not informed of the charges because prompt information is required in order to check the lawfulness of the arrest. But Mr. Cristianino has nowhere been brought before the competent authority.
Did you seek consular access?
Your Excellency, can you please rephrase?
Did you seek consular access to Mr. Cristianino?
Your Excellency, we have the right to the consular access according to the Article 36 of the VCCR, but Mr. Cristianino was arrested secretly and he was also prevented from any kind of the legal recourse, which has been clearly stated in the paragraph Q of the compromise, such that he is prevented from seeking any kind of remedies. Your Excellency,
Speaker 1, Speaker 2, what prevented you from invoking the municipal laws of the country?
Your Excellency, can you please rephrase the question?
What prevented him from seeking the recourse to the municipal laws of the place?
Thank you, Your Excellency, for the question. Your Excellency, Mr. Cristianino was arrested secretly and kept in the custody without legal recourse. So without legal recourse, it means that he has not been provided with any information about his arrest to anyone. He has been arrested secretly, not letting anyone know about it, and also without legal recourse, not letting Mr. Cristianino to seek any kind of the effective remedies, including the right of the consular notification as given in the Article 36 of the VCCR. Your Excellency, do you have further questions?
Please proceed.
Thank you, Your Excellency. Therefore, the secret arrest and the detention of Mr. Cristianino is arbitrary against the Article 9 of ICCPR. Your Excellency, it also must be duly noted that following the detention of Mr. Cristianino, the Republic of Chester also violated the right of consular assistance of Article 36, as just I have mentioned it. The right on consular notification codified in the Article 36(1) of the VCCR requires that any individual, when arrested or detained in any manner, be informed of his or her rights to communicate with the consulate office, and in the informed request be notified the consulate office of his state about his arrest or detention. Its importance has been highlighted in the Lagrand case, that is the Germany versus USA by this court, as well as in Judicial case, that is India versus Pakistan of 2019 judgment too, where the court has clearly stated that the deprivation of the consular notification prevents the national and the state to seek the remedies for the detained person. The judgment of Avena, Mexico versus USA by this honorable court has further emphasized that the obligation of consular notification is unconditional and it cannot be justified in any kind of circumstances. However, However, the Republic of Chester has not provided Mr. Christianino with his individual rights of consular notification, as well as prevented his state island of Tina of the right of the consular assistant to its detained nationals under Article 36(1) of BCCR. Your Excellencies, may I proceed towards the next part of the issue, that is the expropriation of the property of the Prof. Your Excellencies, the property of Prof in Chester was taken over by the government in Chester with due compensation, without due compensation, which is unlawful against the customary international law and the established jurisprudence and the treaty laws. It has been well established in the customary international law, accepted in the Charter of the Economic Rights and the Duties of the State, as well as UN General Assembly on Permanent Sovereignty over Natural Resources and its paragraph 4, as well as the Norwegian ship owners case, that is the Norway versus USA case. And so, in order to comply with the international law, for any kind of the expropriations, it must be made in the public interest in a non-discriminatory manner and a due process of law, and it must be accompanied with compensation. However, the Republic of Chester has failed with these requirements. Firstly, the expropriation, instead of being genuine protest, it was mainly motivated politically, since Republic of Chester itself had distributed the pills winter stock through the compulsory license of the pill, which impacted more in the health crisis. In addition, the government of Chester failed to address the movements of the people of Chester against the health policy it was adopting. And also, instead, in the name of protecting the rights of the women, it also violated the reproductive rights of the Republic of Chester. Your Excellencies, may the agent request for additional minute to conclude the argument?
Yes.
Thank you, Your Excellency. Also, the expropriation was without due process of law. And finally, the Republic of Chester failed to pay the compensation which must be prompt, effective, and adequate. In Santa Elena versus Costa Rica, in its paragraph 71 and 72 has clearly stated that international law permits the expropriatory measures only with prompt payment of adequate and effective compensation, no matter if the expropriatory measure has the laudable and the very beneficial purpose for the society, but the compensation must be paid by the state to its owner. Hence, Republic of Chester refusing to offer any kind of compensation or to negotiate in good faith to give any kind of compensation triggers the state responsibility for unlawful expropriation. Your Excellencies, if you don't have any further questions, may I proceed towards
what is the loss that you sustain for the compensation that you seek?
Your Excellency,
what is the loss that you sustain? What is the proof of the loss that you sustain to ask for compensation?
Your Excellency, it is based on the customary international law, which says that the expropriation, whether it is for the lawful purpose or the unlawful purpose, it must be accompanied with the compensation, and which should be made for the public interest as well as in due process of law. Your Excellency, did I misinterpret the question?
No. I just asked you, what is you seek for compensation? What is the loss that you sustain? What is the proof of the loss that you sustain?
Your Excellency, thank you for the question. Since the profit was taken over by the government of the Chester, it impacted in the substantial and the permanent deprivation of the property of the profit by the takeover. As a result, there was the certain decline in the economic interest of the profit company.
Yes.
Thank you, Your Excellency. Your Excellency, may I proceed towards the prayers? Thank you, Your Excellency. Thank you, Your Excellencies. So, in the light of the issue raised, arguments raised, and authorities cited, the agents for the applicant humbly request before the bench to adjust and declare that the Republic of Chester has violated the obligations, has failed to fulfill the obligations under the international law by the unlawful expulsion of Mr. Christianino, arbitrary detention of Mr. Christianino without legal recourse, and the expropriation of the property of the Prof in unlawful manner, as well as the violation of the rights of the women in Chester itself. May it please the court, it was an honor to plead before the bench. Thank you, Your Excellencies.
Could the courtmaster confirm if I'm audible and clearly visible?
Yes, you are.
Thank you. May it please the court. Greetings of the day. It is indeed an honor to plead before this esteemed bench. So the council seeks permission to collectively acknowledge the bench as Your Excellencies. Is the permission granted?
Yes. Yes.
Much obliged, Your Excellencies. The council appears on behalf of the respondent, along with my co-counsel, and the council will be submitting on issue number 1 and 2 pertaining to the instant dispute in a total time frame of 18 minutes, followed by my co-counsel who would be making submissions on issue number 3 in a total time frame of 10 minutes. We also wish to reserve 2 minutes time for the rebuttals. So with the prior permission of the bench, I will just time myself and begin with my proceedings, if I may.
Yes.
Yes, please.
Much obliged, Your Excellencies. Your Excellencies, before coming to the claims which the respondent plead and while opening the case, it is imperative for the council to make note of the points and also apprise the court where the opposing counsel clearly misled the court. The very first point, they used VCCR, the consular access, the treaty. However, if I may direct Your Excellency's attention on the Moot proposition, the record at hand, the factual matrix, at page number 8, para number T.
Yes.
The bench is with me.
Yes, please continue.
Much obliged, Your Excellencies. In para number T on page number 8, it is clear that Republic of Chester and Island of Tina have at all relevant times been parties to the Charter of the United Nations and all international human rights conventions and treaties. However, contrary to their point of bringing the VCCR, it is submitted that the Vienna Convention on consular access or the consular right is actually not a part of human rights treaties. However, it is part of the treaties that are encompassed under maintaining foreign relations with the state for which one has to be separately signatory, and the facts are silent, contrary to the para number T. So therefore, bringing this particular consular access or this treaty in the instant dispute suffice no purpose because it is outside the ambit of the Moot proposition. Furthermore, my opposing counsels centered around the issue that there has been a gross human rights violation or the violation of any human rights treaty, to which we vehemently refute, and the intricacies of it shall be dealt by my co-counsel in the third issue. However, as a passing reference, it is pertinent to mention that they centered or banked their claim on the fact that there is arbitrary arrest or detention of Mr. Cristiano. Now, in this particular regard, I invite Your Excellency's attention at page number 3 of clarifications to the Moot proposition, if the record is available. Is the bench with me? The
Yes.
clarifications to the Moot proposition, page number 3, point number 24. It clearly states that the domestic laws of Chester supports preventive detention. So all the relevant articles which my opposing counsels quoted with regard to the ICCPR, the arbitrary arrest and detention, falls flat on the very ground that the detention was well within established procedure of law, because preventive detention is a part of the laws of Chester. Per se, for illustration, we also claim that for illustration, in Indian laws also, we do have PSA, the Public Safety Act, and the National Security Act, which centers on this ground of preventive detention, and it has altogether different pedestal. So it is natural for a person to claim that there has been violation of his or her liberty, but the very import of the act or the very import of this law, preventive detention, has a different pedestal, which is well understood by this court. Furthermore, if at all they wish to claim any human rights violation, they also quoted human rights judgment before this court, which was passed by the Human Rights Committee. Now, if at all they wish to make a claim of any human rights violation, since we are party to all the treaties of international human rights law and ICCPR is encompassed in that treaty, so the very ICCPR has constituted a human rights committee which deals with such claims. So therefore, Also, in addition to the exhaustion of local remedies for which they had a particular stance, there is also a customary international law which says that there should be exhaustion of all efficacious remedy, all the effective remedies. And in our opinion, Human Rights Committee or raising a claim of human rights violation before this Human Rights Committee constituted by ICCPR is one of the efficacious remedies which was not exhausted. Thirdly, Your Lordship, Your Excellencies, they also said they themselves affirmed in the fact that they are the co-venturer of Profin, the company which is in dispute at hand. And they have also quoted a case of ICSID in named Generation Ukraine versus Ukraine on page number 2 of their written submissions, my opposing counsels. Now, on this particular context, it is submitted that when they've themselves affirmed in the fact that they're a co-venturer, so a claim on behalf of a company can never be attributed as a claim brought by a sovereign state government, as the case suggests. Because the corporate identity is a different identity under the customary international law on company, and there is a particular concept called as corporate will. So it cannot be lifted because company having an independent corporate entity, a juristic person can sue and be sued in its own name. Therefore, this brings to the very claims of the side respondent that the claims of Island of Tina are not maintainable before the International Court of Justice, given the fact that the instant dispute bears a company versus state nature, contrary to Article 34 of the Statute of the ICJ, entailing state versus state dispute. Not only this, Profin is a pharmaceutical company and it is established rather writ large in the factual matrix. Contrary to the applicant's memorandum submitted before this Honorable Court post 19th November 2021, alleging human rights violation of a foreign national, it is submitted that all of the actions taken by the federal government of Chester post the issuance of health alert on 14th September 2021 were taken against the company Profin and Mr. Cristiano, holding the position and authority of its president. So it is further submitted that in the light that Island of Tina is also a joint venture partner of Profin and also the largest shareholder of Profin, yet the company is a separate legal entity with an independent corporate structure and identity under the basic tenets of customary international law on company. Thus, the corporate wheel cannot be pierced so as to maintain the claims by the Island of Tina before this Honorable Court. Because if they choose to appear before this court on behalf of Profin as a joint venture partner, then the case should have been titled rather before the appropriate forum as Profin through Island of Tina. However, in the instant case, like they bring to the table, the case is titled Island of Tina versus Republic of Chester. Not only this, furthermore, it is a settled position of the international law by way of a Katina international precedents such as Cambrius versus Venezuela and Karen versus India, that the corporate wheel can only be pierced in exceptional circumstances where the structures had been utilized to perpetuate fraud or malfeasance, unlike the instant case. And the compulsory jurisdiction, which perhaps my opposing counsel is banking upon, cannot be made applicable. Because though the parties, Island of Tina and Republic of Chester, have duly signed the declarations accepting the compulsory jurisdiction of the ICJ, it is still not applicable, Your Excellencies, to the instant dispute, owing to the very fact that it is a dispute bearing a nature of company investor versus state. Now, the states in their capacities of sovereign states are only bound by the compulsory jurisdiction under Article 36 of the statute. Therefore, this Honorable Court has the compulsory jurisdiction to hear and decide upon any dispute between the parties in their respective capacities of state governments. It does not bind.
Yes, I have a question for you. Cannot Tina exercise diplomatic protection on behalf of Profin and its president via the beneficial interest principle?
Indeed, Your Excellency, even if we look into the factual matrix and say that there is a beneficial interest principle. However, in that scenario also, the beneficial interest is sought on behalf of Profin. Now, in that particular context, that beneficial interest can be sought had it been a scenario that it is only the state government of Island of Tina which makes the claim of beneficial interest. Now, even when there is a claim of beneficial interest, this makes the dispute company investor versus state. Now, company investor versus state, we have an independent body known as ICSID The case has also been mentioned by opposing counsel. ICSID, International Center on Settlement of Investment Disputes. So that is an appropriate forum or a full-fledged forum, which brings to us the point that there is no exhaustion of efficacious remedies. Therefore, the claim is not maintainable. Not only this, if I may invite your attention of your lordship's attention at para number I of the Moot record, at page number 3, which is also continued on page number 4, if the bench is with me.
Before you get there, so is it your position that any claims of profit with regard to its investment should be referred to the ICSID?
Yes, we bring to the table that ICSID is one of the efficacious remedies, and there is a principle in international law that there should be exhaustion of all efficacious remedies before making an international claim before this honorable court.
So wouldn't that give rise to multiple claims before multiple fora?
However, in this particular context, Your Excellency, it is pertinent to mention that appropriate forums are there, and maybe that precedent or that judgment, though not bound, is not bounding on this court, but it also serves as a persuasive value with regard to the narrowing of the controversy from the very beginning. So efficacious remedy principle is definitely taken into consideration, given the fact that compulsory jurisdiction does not entail in here. And as a supplementary argument, in that context, with regard to your pertinent question, this honorable court also has the right to reject its own compulsory jurisdiction and the right to rule on its own jurisdiction pursuant to Article 36, Clause 6 of the statute of the ICJ. And we have also mentioned a catena of landmark judgments, say US versus USSR, wherein this honorable court itself denied to comply with the compulsory jurisdiction, even if the parties have agreed to it. So we also have a supplementary argument with that regard. So if it may please the court, if I proceed with the submissions.
Yes, please.
Much obliged, Your Excellencies. So the council was inviting your attention on page number 4, para number I, which is continued on page number 4. It states that the Prof took permission from Chester, that is our federal government, primarily for the research and development of new biological compounds. And under the permission, because this agreement has or establishes the contractual obligation of quid pro quo, something for something. This is why this investment agreement, pursuant to this investment agreement, they were also obliged to inform all the research and trials and any adverse outcome. And it is categorically mentioned in this particular investment agreement, if your lordship may kindly see, that breach of this obligation can lead to serious actions by Chester against Profit, which is why, pursuant to which this action was taken. Furthermore, if you bring to the table, Your Excellencies, their claim, they also said that in the next limb of the argumentation, they also brought to the table the very fact that Chester, our country, has undermined the agency of women to give informed consent. Now, in this particular regard, it is very pertinent to mention, Your Excellencies, that he who comes in equity must come with clean hands. This is because when my opposing counsel brings to the table that Chester has undermined the agency of women to give informed consent. Now, informed consent is always given for the medical purposes or the scientific experimentation, which is performed on a body. And when we say that women have an agency, this means that women have the authority to have an agent sign on her behalf for the informed consent. Now, when they plead that women have agency and Chester has undermined their agency, now there is an absolute dichotomy between their stance and conduct. Because if I may draw your lordship's attention on, again, para number I, on page number 3 of the Moot record, if the bench is with me.
Yes, please continue.
Much obliged, Your Excellencies. In this particular regard, continued on page number 4, it clearly said that patients were required to sign a waiver from which had ironclad indemnity clauses against claims from any sort of side effects during the trial. Now, pursuant to this object, If your lordships may kindly see the succeeding para number J, it is writ large that during the course of first phase, large number of women had entered into the trial run agreements by men in their family. Now, on the very face of it, if a contract or if an agreement comes into existence which is coerced or which has undue influence or which has unqualified agency, the contract itself stands invalid, which was entered into by Profin. So therefore, the violations of women's rights are done at the hands of the Profin and not Republic of Chester for that matter, considering also the health crisis which ensued after the very consumption of this pill, which is evident on para number N of the Moot record at page number 6. At page number 6, para number N, it is clearly stated that the consumption of this pill led to neonatal deaths and overbleeding, menstrual problems, reproductive health crisis in women. So therefore, they've actually breached the very right of women to reproductive health, which they claim. So therefore, he who comes in equity must come with clean hands. This is our submission with this regard.
Madam Counsel, see, you can't, when you're defending your own law, which seems to take away the free choice of the women, you can't put the blame on the other side and say that he should have equity. It is a question of you have to justify your law and not put it on the other side.
Indeed, Your Excellency. This is actually the next limb of my argument, which states that we did impose a ban. Your Excellencies, I see that my time is running out. So if I may ask for an additional 1 minute so that I can sum up my argument with this being said.
Yes.
Much obliged, Your Excellency. Your Excellency, it's pertinent to mention that we did pass a health alert after we saw that there are major side effects of this winter stock pill, and pursuant to that health alert, which was an executive order. It is also mentioned writ large in the Moot proposition in para number P of our Moot proposition that it was an executive order which was passed, that is the health alert, which banned the contraceptions, prohibited the consumption of this winter stock pill and also the MTPs. Now, the object was that because of the fact, given the fact that women already have chips inside their bodies now, and given the fact that winter stock pill has led to a lot of health crisis, it was imperative to us to take this step, which is just an executive order per se, because it has a tenure. It is not a constitutional amendment taking away the rights of women in entirety for all times to come. But this was actually used to avert the health crisis. Now, there was a biotechnological weapon which was being used at the hands of this island of Tina, because it is also pertinent to mention that on para number O of our Moot record, which is on page number 6, if the Excellencies are with me.
Yes, please continue.
Yes. At para number O, it is pertinent, it is evident that the highest intelligence bureau of Chester came across some confidential data made by Profin and communications with the island of Tina, which revealed that under the guise of research, Profin has launched research on a rare genome project that can have impacts on DNA and genetic diversity, which was visible indeed, taking into consideration that there were neonatal deaths, adverse reproductive health of women, and the gender ratios stooped down to a different level. So in this regard, the contraceptives were banned. Contraceptives were only banned for women. To be noted, contraceptives, the males can use the contraceptives in pursuit of spreading infection of, say, sexually transmitted diseases. But women contraceptives also include pill, which might lead to adverse effects given the fact that the chip is right in their body, and it might have adverse outcomes which are unidentified in genetic engineering and biotechnology. So given that fact, an abortion, the MTP was also banned because it would lead to further infertility rate. And moreover, the abortion, the MTP ban is definitely, women do have inherent right to reproductive health, but it's always subject to the state sovereignty, because an individual interest, Your Excellencies, is subservient to the public interest. And in public interest, it was imperative for Chester. And not only this, Chester has always been very conscious about the rights of its women citizens, because it is evident from the Moot proposition. I again invite Your Lordship's attention at page number 2 of the Moot record, wherein it has been categorically mentioned that Chester has a woman prime minister who was elected, And Chester, on page number 1 of the Moot proposition, it clearly states that at para number A, if the bench is with me, the Republic of Chester is predominantly a welfare nation with policies focused on social justice measures tuned to the welfare of its large 1.35 billion population. And at page number 2, at para number E, it is pertinent to mention that we launched a national healthcare system which was central to women's rights. So indeed, in order to protect women, in pursuit of protecting women against the adverse outcomes which is likely to happen, therefore, it was imperative for us to issue that health alert in this regard. And the MTP, the ban of MTP, is also well within our state sovereignty for a specific period, considering the grave health crisis, and definitely it is within the scope of state sovereignty. And in this,
So you mean to say that it is within the scope of state sovereignty? Therefore, island of Tina has no right to approach this ICJ, because they are all subject. They are all your subject. The women which are in this list are all your subject.
Indeed, Your Excellency, thank you very much for that pertinent question. In this regard, it is submitted that the women are definitely, they are not our subjects, but our citizens, very dignified citizens, because we ensure them fundamental rights. But taking into consideration the crisis and the policy imbalance which led to gender different ratios, it is also the responsibility of the state to take care of the public policy. And taking into consideration, if I may plead here, that even in the United Nations Economic and Social Council report of 2016, it observed that right to reproductive and sexual health is a human right that is required by a person to observe a quality life, hereby meaning that a person's quality of life might depend on right to reproductive health, but the reproductive system is not essential for a person to survive. So arrest of this particular right for some period by an executive order is definitely within the state sovereignty to avoid the health crisis in this particular regard, because we have to ensure their right to life first, which is jeopardized by island of Tina, given the fact that the chips or the data chips are inside their bodies, and we are again seeing that there is a reproductive health crisis which might lead to a threat to their lives.
Thank you.
Yes. Council,
said that,
yes.
yes.
Council, you, on several occasions you spoke about a public health emergency. Why is it that Chester did not notify the World Health Organization in terms of Article 6 of the International Health Regulations of the existence of a public health emergency?
Your Excellency, in this particular regard, it is submitted that Chester was in a state of limbo, which was definitely kept by island of Tina, because because they informed that the trials are successful, by which they meant that the trials are really going good. However, when pursuant to the policy group report which stated that there are health crises, we convened a high parliamentary level committee, a meeting whereby we issued an health alert to avoid the crisis. However, it is also stated that the report which came of highest intelligence report, it quite came later in the course of the trials, for which it was very difficult for us to actually cater to the situation, because it involved biotechnological weapons, and to identify Winterstock pill, which was consumed by women, as a biotechnological weapon. It took us research which was done by the highest intelligence bureau of Chester. So we were in a state of notifying the WHO. However, the very fact that in a state emergency where there is an imminent threat to national security, because with the press button ease, now this biological data could have been sent to a foreign nation, and biotechnology, and it could have transferred across the borders. So in this particular regard, it was imperative for us to derogate from that formality and first do justice to our citizens. If I'm audible.
Your time
So
is up,
indeed. If I'm of no further assistance to this honorable court, I would leave the floor to my co-counsel.
Yes. Yes.
Much obliged, Your Excellency. It was an honor to plead before your good selves.
Honorable bench, is the council clearly audible and visible?
Yes.
Yes, you are.
Much obliged. The council seeks permission to address the bench collectively as your lordships.
Yes.
Much obliged, Your Lordship. The council seeks permission to move forward with the issue at hand.
Yes.
Much obliged. Your Excellencies, Republic of Chester could confiscate Profin as it did under the power given in the official order. Furthermore, President of Profin was also lawfully detained, and subsequent denial of his diplomatic rights are justified and hence do not deserve compensation. Honorable Justices and Excellencies of this Honorable Court, before moving forward with the issue at hand, the Council would like to point that our learned applicants on the other side misled the court by stating that there is not a situation of national security, but the Council for the respondents would like to point that Mr. Cristiano was put under the preventive detention due to matters concerning the national security, as the data that was generated through the genome project or through the research is highly inflammable, given the fact that it was being used for a genome project that would impact the citizens of Chester at large. Furthermore, deliberate concealment of the fact for this point, the Council requests this court to refer to paragraph O at page 6 of the Moot proposition, if your lordships are well with me. Your Excellencies, it clearly states that the Intelligence Bureau of Chester came across a confidential data maintained by Profin in communication with Island of Tina. The very fact it was a confidential data, it shows that it was a concealment, deliberate concealment of the fact that was coupled with the side effects that surfaced in the later course, makes it clear that there could have been a situation of biotechnological war, as the consequences of the winter stark pill, which was surfaced at the later course of the trial, impacting the women's reproductive health, was apprehended to be a biological weapon, for which the Council requests the Honorable Bench to refer to paragraph M and N of the Moot proposition. If your lordships are well with me, it clearly states that in the paragraph first, that in the meanwhile, large side effects of pill winter start began to slowly emerge. And in paragraph N, it clearly states that the report suggested that women after consuming the pill began to suffer several adverse health consequences affecting their reproductive health and their menstrual cycle. And thus, it is most humbly pleaded that it is turning out to be a biological weapon. Moreover, given the fact that there is no material on record stating that the data chips were removed from the women, it is inevitable to conclude that the Chester is at great risk of losing out women's personal biological data to Profin, which is the violation of OECD's guidelines of protection of privacy and trans-border sharing of the data, and thus thereby a sovereign state of Island of Tina. The data could be shared with the sovereign state of Island of Tina, which Profin was already doing, for which the Council requests again your lordships to refer to paragraph O of the Moot proposition, which it clearly states that the highest Intelligence Bureau of Chester came across a confidential data maintained by Profin in communication with the Island of Tina. So thus, it is inevitable to conclude that Chester is at great risk of losing out of this women's personal biological data to Profin and a sovereign state of Island of Tina with a press button ease, because the chips are yet in the bodies, and thus creates a potential and great threat to national security, because it is endangering the population at large, the women population at large in Chester. Moreover, further justifying that the president of Profin was lawfully detained, Article 9, Clause 1 of ICCPR, Article 6 of ACHPR, Article 7, Clause 1 of AMCR, and Article 5, Clause 1 of the ECHR provides that a person can be arrested or detained as per the established law. And if the lordships, the Council seeks your request to refer to the Moot clarification, which at page 24, which clearly states that the laws of Republic of Chester allowed for the preventive detention and thus does not violate any international legal principle.
Mr. Counsel, in terms of your law, you can just detain someone without communicating any reasons or grounds for detention.
Thank you for the pertinent question, your lordship. To answer the same, the Council requests this honorable bench to refer to para Q of the Moot proposition.
Yes.
Your lordships, at para Q, it has been clearly mentioned that the brief facts for which he was detained was communicated to him, as it is clearly mentioned that he was arrested secretly and placed in custody without any legal recourse, as he was considered to be indulging in reckless profiteering and crime accused in health crisis created by him through the clinical trial in the state of Chester. The Moot proposition in itself clarifies the fact that the brief reason for his preventive detention was told, and as per the international legal framework, and as has been held in the cases of H. Van Alphen versus the Netherlands, L. Magna X Pilfert versus Zaire, and M. Jano versus Madagascar, it is a clear fact and has been held by the International Tribunal that if a person is told about only the brief reasons for his preventive detention, then it is justified by the international law, if the same is provided according to domestic laws, and the same has been done by Republic of Chester. Your Lordship, these reasons justifies that Mr. Cristiano was not illegally detained. Rather, he was detained due to
Just,
pertaining situation.
just a minute, Counsel. Arresting him secretly, is it established procedure?
It has the essence of preventive detention, Your Lordship, because it might create a public outrage, because it has created a national security havoc. Because reason being, Mr. Cristiano, being the largest shareholder and the president of Profin, have the essential or the key data relating to the personal biological and the DNA of the citizens of Chester who indulged into the clinical run trials. Thus means that if it has been disclosed, or if by chance it was not secretive in nature, the other agents of Mr. Cristiano might disclose the data to Profin or the other branches of Profin that was established into the other states. And thus it was to be secretive in nature to protect the interest of the citizens of Republic of Chester. That's why it was as per the preventive detention law, as has been justified by the various international conventions, as just has been mentioned by the Council, as per Article 9, Clause 1 of ICCPR, Article 6 of ACHPR, and Article 7, Clause 1 of AMCR, and Article 5, Clause 1 of ECHR. If your lordships are satisfied, the Council seeks permission to further move forward with the issue.
Yes.
Much obliged, your lordships. Your lordships, moreover, notwithstanding any claim of the applicant, it is an established fact that on 14 September 2021, an health alert was issued which totally banned the sale and production of Winterstock pill. If we were to say that we were having a bad faith in arresting Mr. Cristiano, then why would we have arrested him after 3 months of time gap when the health alert was issued? Because health alert was issued on 14 September and Mr. Cristiano was arrested on November, that is 19th November. And the reason was of reckless profiteering, because he violated the municipal law of Republic of Chester by engaging in the said action that was totally banned. And thus his arrest is not illegal, but is totally justified by the international legal framework itself.
Yes, I have a question for you. Isn't the expropriation of the assets of Profi?
Yes, your lordship.
Yes. So wouldn't this if it amounts to expropriation, how about compensation?
Indeed, your lordship. When it comes to the compensation part, it has been established by the internationally customary law, and as per also the case of Laundria claim case and D Sabla case and Anglo-Iranian Oil Company series case that has been adjudged by ICSID and ICJ itself, which clearly states that the state could take appropriate actions against the violation that has been committed by an investor in the host state, and such action do not require any form of reparation to be paid by an investor. Because your lordships, your excellency, it must be understood here that the property was not confiscated or expropriated due to any form of nationalization, because under the form of nationalization we have the duty to compensate. But the property was not confiscated due to nationalization, but it was confiscated in the form of penalty. It was a penalization on the Profin itself, who was engaged into the violation of municipal laws, who violated the agreement obligations and put the national security at risk of Chester. Thus, the property was confiscated and thus does not require any compensation, because it was not a form of nationalization or taking a property or expropriation, but a confiscation in the form of penalty. Thus, a compensation is not to be given, because that is what penalization means. And that's why it also does not amount into unjust enrichment, because unjust enrichment, the case of unjust enrichment without compensation arises only in the case of nationalization of a certain industry. But the case here pertains to the violation of municipal laws and putting a national security at risk. It was a national threat. And to curb that national threat, Profin was confiscated. That's why compensation should not be given to the Island of Tina or Profin. If your lordships are satisfied, the council seeks permission to move forward with the issue that how expropriation is right and confiscation is justified by law.
Yes, proceed.
Much obliged, your lordship. Your lordship, If we move further, and if your lordships may kindly refer to page 22 of the written submissions of the respondents of arguments advanced, paragraph 54, there is a case called Desert Line versus Yemen and Rumali versus Kazakhstan, which clearly states that respect and abidance of the host state laws and regulations is an established international legal framework. And your lordships, the council seeks permission to gracious extension of a minute to wrap up the argument of the expropriation.
Yes.
Much obliged, your lordship. Your lordship, as has been held in these cases, respect and abidance of the host state laws and regulations is an established legal framework wherein every foreign investor is bound to not only fulfill the agreement obligations, but to abide by the laws and regulation of the host state. Since both the agreement obligations and the host state laws are violated, as the Profin and Island of Tina, that is the co-venture, does not disclose about the genome project that was being carried by Profin under the guise of carrying the research, violated the agreement obligation, which clearly stated that a person, that the Profin, the company, need to disclose every research, every side effects or every outcome of the research to Republic of Chester as an agreement obligation, which was violated by them. And thus confiscation under the first part becomes justified. And when it comes to the second part, they fail to abide by the laws and regulation of the host state, as they clearly violated the health alert norm that was released on 14 September. And thus, that's why on after 3 months in 21st November, they were arrested. And thus, the council seeks permission to move forward with the prayer if your lordship does not have any questions pertaining to the issue at hand.
Yes.
Much obliged, your excellencies. Wherefore, in the facts stated, issues raised and arguments advanced, authorities cited and submissions made hereto above, and those to be urged at the time of hearing, it is humbly prayed that the honorable court may be pleased to dismiss the instant application by the Island of Tina, herein the applicant with heavy cost, to declare the women did not have unqualified agency over giving informed consent, and their inherent right to reproductive health under international law is subjected to state sovereignty, as these rights has been violated by Island of Tina and Profin. And lastly, that Profin Chester could confiscate Profin, and the Mr. Christiano's legal rights are not violated, and he was lawfully detained and thus does not deserve any compensation or pass any such order that it deems fit in justice, equity, and good conscience. Much obliged, your excellencies.
Your excellencies, the council seeks permission to submit the rebuttals.
Yes.
Much obliged, your excellencies. Your excellencies, firstly, with regards to the arguments made for the lawfulness of preventive detention. Your excellencies, the councils have submitted that preventive detention in this particular matter has been made pertinent to reasons of national security. However, your excellencies, they have failed to establish that there is an immediate threat posed by Mr. Cristiano. Additionally, your excellencies, they have invoked reasons of data security, data protection threats. However, your excellencies, if you see in the Moot proposition, paragraph K, the last line, the Republic of Chester has no data protection framework. As such, the detention in this particular regard cannot be considered lawful. Your excellencies, the next argument is with regards to VCCR Article 36. Our learned counsel pointed out that we are limited by the facts to say that both parties are party to the VCCR. However, your excellencies, the body of international law has well accepted the right to consular access and the obligation of states to provide consular access. As such, your excellencies, we submit that consular access in accordance with Article 36 of the VCCR is an obligation under customary international law, since it is supported by state practice and opinion juris. Your excellencies, additionally, we would like to address the fact that our learned counsels have time and again said that efficacious remedies with regards to ICSID should have been pursued. However, your excellencies, there is no such obligation on part of the Island of Tina to make such a submission. The council also very conveniently looks over the submissions that the Island of Tina has made with regards to the rights of the women of Chester, which have been unlimited unlawfully. No justifications yet have been provided in accordance with international human rights instruments with regards to the restriction not in accordance with ICCPR, neither Article 4, neither Article 5. Your Excellencies, we also submit that for the island of Tina to submit human rights claims, claims with regards to the violation of the rights of an alien, expropriation of a property without compensation, as one of our Excellencies has pointed out, would be very cost ineffective. Your Excellencies, we also submit that in regards to the doctrine of clean hands that the respondent has invoked in this particular regard, Jadhav case in paragraph 61 of its judgment provides that the doctrine of clean hands cannot be invoked to render the jurisdiction of a court inadmissible. Your Excellencies, in this regard, we submit that even if we do not have clean hands, which we completely deny, we are still capable of submitting claims. We still have standing with regards to the claims that we submit. Your Excellencies, again, with regard to the contracts that the Learned Council has pointed out, is actually declared. Your Excellencies, may I quickly wrap up the rebuttals?
Yes.
Yes.
Much obliged. The council has pointed out that the contracts were invalid since the time of enforcement. However, Your Excellencies, the Republic of Chester waited until this moment to declare that they are invalid, when since the very beginning of the research, the local government of Chester has been involved in the entire process. As such, Your Excellencies, we submit that we have established that the Republic of Chester has breached several obligations under international law, in particular articles under the ICCPR, and that falls in the compulsory jurisdiction of the ICJ in accordance with Article 36. That will be all, Your Excellencies. May it please the court.
Thank you.
Permission of the bench, may I proceed with the rebuttals? I will time myself.
You're not audible.
Am I audible, Your Lordship, now?
Yes.
With the permission of the bench, may I proceed with the rebuttals? I will time myself for 2 minutes.
Yes.
Yes.
Much obliged, Your Excellency. Your Excellency, we are clear on the fact that we are refuting that there is any human rights violation, and therefore, when there is no human rights violation, which we have vehemently pleaded and proven before this court, so in this regard, there is no compulsory jurisdiction which can stand tall under Article 36, Clause 2, Subclause C and D. So therefore, there is no breach of any international law whereby the claimants, the applicant does not have any claim, or their claims are not maintainable before this court. In regard to their rebuttal that there is preventive detention, and when we did not discharge our onus of telling how Mr. Cristiano is an immediate threat, I believe that we have well within stated in our arguments that he is the man who has the data with the press button ease, and there is a threat to national security because biotechnological weapons, the gravity of biotechnological weapons is writ large also in these trying times. Further, when they say that there is no data protection law, so we do not have at all the authority to actually take into consideration the rights of our citizens, then in this regard, it is very vehemently pleaded that the law arises out of necessity and not luxury. Having said that, relying on the international precedents or international legal principles, we also have the OECD guidelines, because my opposing counsel seem to have been banking upon international legal principles, which makes us or puts us into a position to also place on record that OECD guidelines on the protection of privacy and trans-border flows of personal data, Part 2, Clause 7, Organization for Economic Cooperation and Development, is also a legal principle which confers the very duty on every nation so that we can have protected data. Furthermore, they also referred to the ICSID, and they said that there is no hierarchy, so we did not exhaust any efficacious remedy. But in that regard, since we portrayed that this dispute is more or less like a company investor versus state dispute, so the ICSID is appropriate forum. Furthermore, there is no exhaustion of local remedies, because in this particular dispute, there is no fact or material on record which states that we have actually, or Island of Tina has actually presented this case before any municipal court, because if they can come on behalf of Cristiano and Prof here, they can also proceed with the cases in the municipal, in the domestic courts as well. And lastly, they said that there is doctrine of clean hands. I guess we have vehemently pleaded this case. And I also just seek a gracious extension of, say, 15 minutes to wrap up my rebuttals, if it is granted.
Yes.
Much obliged. Lastly, they said that we did not wake up from the sleep that the contracts were entered into by coercion or undue influence. Well, in light of the fact that they, under the guise, Island of Tina and Prof, under the guise of doing research and development, did not oblige to tell us about the Genome Project, we also believe that being a governmental body who has given the due permissions in the welfare of the state, it was the duty of Island of Tina to make it available that how are they going to enter, or the contracts which are being entered in the territorial jurisdiction of this country. So having said that, if I'm of no further assistance to this honorable court, I leave the floor to your good selves.
Thank you.
Much obliged. Much
Thank
obliged.
Much obliged, Your Lordships.
Your Lordships, now I request you to kindly move to